Okay, Swadkap, I'm Punsawangdi. I have already introduced myself last time during the second recording, and now I want to mainly focus on to the activities of our office. So the Thai Arbitration Institute is all about the arbitration. So today I'll be talking about arbitration in general. So later I'll be talking about focusing more into international arbitration. But today I'll talk about arbitration as a whole. What does it mean? So my talk is mainly focused on two people who had never tried arbitration. And for people who had already done arbitration, it's sort of a reminder. And people who heard about it and has not tried, it's sort of information. And for a person who had never tried arbitration, who had never heard about it, it's sort of a knowledge. So with this, first thing I think what we need to know is about arbitration. Actually, arbitration is a method of resolving the civil, commercial, or contractual dispute through the involvement of third party, whose decision will be final and binding to the concerned people. So Mr. A and B, they sign the contract, and in their contract they want to include arbitration clause, saying that if there is dispute while the work is going on, or after the completion of the work, if there is any problem, they want to solve it through arbitration. So if that is the case, they will include arbitration clause in the contract document, or they can also sign a separate arbitration agreement for resolving the dispute. So this is the involvement of a third party, a neutral party, to look into the matter instead of going to the court. So in the court of law, no, it takes a lot of time. We have to wait in your queue, you have to wait for your turn to come, and there are certain prescribed rules and procedures like criminal procedure code or civil procedure code, and you have to follow that structure, and the party as an individual has no freedom, there is no flexibility. You have to follow that rules of procedure. It takes time, and for business people, there is no time to wait like that. So for that, they can have a choice to arbitrate the dispute through arbitration. So that's why it is sort of an alternative to the adjudication of the case before the court of law. Then one thing is that if the parties had already signed an arbitration agreement or has included arbitration clause in the contract document, and later when there is any problem between the parties, if one of the parties goes to the court of law saying that I want to file a case on a particular dispute, if that is the case, the first thing the court will see is that whether there is an arbitration clause in the contract document, or whether they have signed the arbitration agreement or not. The court will see into that. So in case if there is an arbitration agreement or arbitration clause in the contract document, then the court will not entertain the case. No, the court will not entertain the case, and will simply say, order the party to firstly exhaust or follow the arbitration procedures. Then only after that they can look into it. So that's why the court will not entertain the case as such. So it has to be processed through the arbitration. So that's why. So arbitration will go through the arbitration agreement. They will follow whatever the procedure is there in the arbitration agreement. So this is the main difference between the arbitration and adjudicating the case before the court of law. And in the arbitration, what actually happens is that instead of judge before the court of law, we have arbitrators. So in the arbitration, the two parties like Mr. A and B will choose their respective arbitrators. Okay, after they have chosen their respective arbitrators, these two arbitrators who will be representing A and B will choose another arbitrator, who will be the third arbitrator or will be the chairperson or chairman of the arbitration. So that way we will have 3 arbitrators to look into the matter. And sometimes party can also choose only one arbitrator to represent them. So that will be sole arbitrator. So when there are 3 arbitrators, means there will be an arbitral tribunal being formed who will look into the matter. So this is how the parties will appoint the arbitrator, and once the arbitrator has been appointed, the arbitral proceedings will follow. And when the arbitration proceeding starts, the arbitrals do not have that much of authority or power to do what they like. If the parties had already stipulated a procedure to be followed during the arbitration, the arbitrators will have to follow that particular procedure. And if parties had failed to stipulate certain sort of procedure in the arbitral agreement, then at the request of the parties, the arbitrators can also set up rules of procedure for following up the arbitration. So this is how the arbitral proceedings will go on. And the other important issue is that the parties will also choose which sort of law they want to follow for their arbitration. And if they choose a particular institute, the arbitration institute of a particular country, then they can adopt the rules of procedure of that particular institute of a country. So then they will follow everything as per the institution. If not, they can also have their own ad hoc arbitration, wherein they will choose their own procedures and they will follow that. So this is how the arbitrators will work on the arbitration. If the institution has been chosen as a medium or mode of arbitration, then certain framework the institution will offer, and they'll have to work within that framework. So that's why the arbitrators will have to work within that, and that is how we go on proceeding with the cases. So for that in that regard, we are saying that Thai Arbitration Institution, we have our set rules based on our act. So if you all choose to choose our institution to process the case, we have a very good rules of procedure to be followed. So it's very specific, and it will make things for sure to be resolved within a very good span of time. It will not take much time, I mean to say. And for that reason, the arbitration has a lot of advantages. The first and foremost thing is about the enforceability of the award. If you go before the court of law, how long it will take? You start a case from the trial court, the court of the original jurisdiction, then there it takes years. After that, a party can appeal to a higher court. Then there it will take few more years, and thereafter one party is not happy, it will again appeal to the higher appeal court. There will take a few years, and that way it takes a lot of time, and then by the time the case is over, the parties might die or something might happen that way. So there is no surety of the result as such. But in arbitration, once the award is passed by the arbitral tribunal or by a sole arbitrator, there is no appeal on that. That is final and binding, because that is the decision of the arbitral tribunal has already been consented, agreed by the parties. So that's why there is no further appeal. So when they go to the court of law, means it is for enforcement. Only saying to the court that this is the award which has been finalized, now we want to enforce. So it is only for enforcement, it will go to the court, and there will be no appeal on that. The appeal will be very rare, only in very few cases, saying that if one party can prove that he was not given a chance to submit his things, or he was mentally not sound, or that whatever the arbitrators had decided is not within the purview of what they have agreed. or if the issue that has been resolved between the party is against the public policy. So on that very rare case only party can appeal against the award. Other than that, the award is final and binding, and that's why we can always see the end result. It will not take much time like the courts. So that is one of the biggest advantages where we can save time and cost. The second factor is that it's about the confidentiality of the matter. In the court, it's a public trial, or it's a public hearing, and all that many people come there and they know about it. It will be published in the media after the judgment, and there is no confidentiality of the issue or the matter. And that's why confidentiality of the matter and the issue is one of the most important thing, and is one of the very important sanctity of the arbitration. The third thing is that the neutrality of the arbitrators. So A will choose, supposing Mr. A will choose one arbitrator, B will choose another arbitrator. Even these two arbitrators, they cannot be biased or impartial to other parties, saying that I have been chosen by this party, so I have to favor that party. Or that party cannot say that this arbitrator cannot say I have been chosen by this party, I have to favor the person who has chosen me, and then I should be biased on others or something like that. So there is no attachment, or there shouldn't be any partiality. So all arbitrators will have to work with one vision only, and that's where the neutrality. And the third arbitrator appointed by these two arbitrators is the most neutral one. So that's where the impartiality of the arbitrator is one of the biggest the advantage of the arbitration procedure. Though the individual can challenge on the impartiality of the arbitrators, there are certain procedures to be followed again. So that's why these three things are very important of the aspect of the arbitration, and especially for the business people, there is a biggest advantage to them. And other thing is that we can always see that as overall now I want to focus that in almost all the cases, arbitration results to a final and binding decision which are enforceable before the court of law. So most of the time the awards can be enforced through the court of law. So that's why, since Thai Arbitration Institution has been dealing with arbitration for last 27 years, we have such big experience, and also, as I already said before, we have experienced arbitrators in our list. Take advantage of them. And we also deal with international arbitration. So people all over the world, whoever feels that Thailand is the appropriate place, and we are one of the institutions here. We are government institution, and that's why we have so much of we have facilities and all that thing. So with this, I want to just only sort of introduction about our office and about the arbitration. So next time I'll be talking more into the international arbitration, and I'll see you next time on my next talk. Thank you.